I'd like to introduce our final speaker of the day, Lyndon Sommer of St. Louis's Sandberg Phoenix von Gontard. He focuses his work on the areas of commercial litigation, products liability, and toxic tort litigation. He also specializes in professional negligence cases involving CPAs whom he has successfully defended at trial and on appeal. Throughout his career, he has handled more than 100 professional negligence cases, and he has also defended attorneys and financial advisors in litigation and arbitration. Please help me welcome Lyndon Sommer.
Thank you, Scott. This morning, I'm going to discuss the challenges that defense counsel have when plaintiffs' lawyers advance bad faith allegations in a lawsuit. Now, I know it might be hard to believe, but there's members of the plaintiffs' bar who think that if they file a lawsuit, they make allegations that the damages exceed policy limits, then they should receive the policy limits. And if they don't, then an insurance company is responsible for bad faith. There's been an increase in bad faith litigation and claims. This is mostly true in states where insurance companies want to avoid coverage litigation. This is true in Florida, Texas, West Virginia, and in Missouri. Now, why is that the case? Well, because some courts have a desire to find coverage. For example, in Missouri, where I practice, the Missouri Supreme Court finds in favor of coverage and against the insurance companies approximately 80% of the time. Another reason that there's been an increase in bad faith litigation is because some states have statutory provisions which allow an insured to confess a judgment in consideration for plaintiff's agreement that they will not execute on the judgment against the insured personally. In Missouri, we call this the rollover law. It's as if the plaintiff's lawyer is Marlon Brando in The Godfather and makes sure a client an offer he cannot refuse. Another reason is it's a means to obtain more money than the underlying claim is worth. Once you have a judgment in hand, plaintiff's counsel simply needs to go and try and enforce the judgment. That judgment is often substantially higher than the judgment that you would receive in the underlying case. Now, what are the methods of setting up bad faith claims in order to obtain a judgment in excess? Well, first, there's a bad faith failure to defend. And in those cases, a policyholder is sued, sends the lawsuit to the insurance company, and the insurance company decides there is no coverage and will not provide a defense. But this scenario also lays out how the bad faith failure claims that are made in cases that we're defending come about. So plaintiff's counsel will find out there's no coverage. They will not be happy. How are they going to get paid? They then start scratching their head and think, I need to go the bad faith route. If they go the bad faith route, they will then work with the defendant in the case who's not being defended by a lawyer. There will be a trial of the case. They will go in front of a judge, and a judge will hear evidence on liability and damages. But that's all the judge is going to hear is what the plaintiff puts on in the case. Consequently, liability is secured, 100% fault on behalf, 100% fault on behalf of the defendant, and then the damages or whatever is recommended. Now there's a judgment. The defendant in the underlying case, the policyholder, will walk pursuant to the agreement. Now, two things can happen, and all states are different. But it's possible that plaintiff's counsel will just file a bad faith claim against the insurance company because there's been an assignment of the rights. Or, at least where we practice, they can garnish the insurance company. The second one is a bad faith failure to settle. And this is what you see typically when counsel is involved. During this phase of bad faith claims, you're defending the lawsuit, and plaintiff will say, here's a policy limit demand. If you do not accept this, then if we recover a verdict later in excess of the policy limits, we will take an assignment of rights and we will move for bad faith. A jury concludes an insurer ignored financial interests of the insured by turning down offers to settle within the policy limits. That's what is necessary to establish the bad faith. But the factors that they consider in reaching that come out of what defense counsel did in the underlying defense of the case. Did you fully investigate the claims? Did you consider the severity of the damages? Did you consider that the verdict could come in excess of the policy limits, which infects the insured? Did you refuse to consider a settlement offer, or did you fail to advise the insured of the potential for an excess judgment? Now, why would a plaintiff be motivated to go the bad faith route? Well, first, they could have very weak liability in the underlying case. If plaintiff's counsel is thinking, I'm only going to win this case 20% of the time, but I've got good damages. Let's assume for a moment there's credible damages of $4 million. We have a $2 million policy. If you blackboard that, then a reasonable settlement value might be about $400,000. But if they go the bad faith route, what they would be able to do is make a $2 million policy demand with the threats that if we get the verdict of $4 million, because it's credible damage evidence, all they need is the verdict and they're going to get there, then we will get a bad faith claim against the insurance company, because at the end of the day, we will tell the defendant we will not personally execute the judgment against you if you assign the bad faith claim. The second way is that if you find out that the estimated likelihood of success on a bad faith claim is greater than the underlying lawsuit. Now, this happens with very sophisticated plaintiff's lawyers who are well-versed in insurance law. And some of those we have in our practice in the Kansas City area. They will file the underlying case for the purpose of setting up a bad faith claim. And they may say, once we have judgment in hand, although I estimated 20% on the underlying claim, I think the bad faith claim is worth 40%. And then when they come to the settlement table, the example I gave you, it's not a $400,000 settlement analysis, but significantly higher than that. In addition, if you obtain a judgment by the bad faith route, you've eliminated plaintiff's comparative fault. Because when you go in front of the judge and you have the trial, the defendant's not going to be represented by counsel. If they've agreed to the rollover agreement, you're gone. The person that's defending them is out, and they are there working with plaintiff's counsel. There will be no evidence of plaintiff's comparative fault, which increases the judgment. In addition, you can have a predetermined allocation of co-defendant's fault. I recently had a case where the co-defendant did not have any insurance coverage whatsoever. There were rollover agreements offered throughout the case. It was not a rollover situation at the end of the day, but the reason they did that was they would have worked with my client to establish that the culpable co-defendant did not have fault. And in addition, you can obtain a substantially higher judgment because there's not going to be evidence of damages. Let's go to the underlying case. Defense counsel is retained. They can be retained under a reservation of rights or no reservation of rights. Under either scenario, there is a tripartite relationship here, and while the state laws differ, the one universal truth is that the obligation of defense counsel is to the insured. And while some states say that the defense counsel has obligations to the insurance companies, in fact, most cases state that, the obligation to the insurance companies exists to convey information, and much of it is privileged unless the obligation of the insured conflicts with the insurance company. Now you begin your investigation and early evaluation of the case, so we're off to the races. Now there's an early policy limit demand. You'll get this when you get a case, perhaps you've done some initial investigation, you've exchanged written discovery, and then you find a letter from plaintiff's counsel for policy limits, and you have 60 days to respond. What do? Well, obviously, you immediately report that to the insurance company and the insured. You should advise the insured to seek private counsel, their own personal counsel, to advise them on the rights vis-a-vis the insurance policy. And frankly, as defense counsel representing that individual in the underlying case, your job is substantially easier if they have their own personal counsel so they can receive the offers to roll over and advise them. You then tell the insured to confirm there is no excess coverage under their policy, which should have been done initially anyway, but it's a check mark if you haven't done that. You then need to aggressively obtain as much liability and damage information as possible because the meter's running on the demand. You should obtain the insurance limits for the co-defendant because you're going to need to evaluate how this will play out at the end of the game and if the co-defendant is likely to also roll over or if plaintiff's counsel will decide not to go after the co-defendant as much. Continually update your evaluation on liability and damages, and literally in the early demand scenario, this is happening daily and weekly that you'll be asked for that information because now the insurance company will have coverage counsel involved who will be calling you frequently saying, has anything changed? Has anything changed? Establish a detailed paper trail of your request for information. This will enable you to reasonably ask for more time from plaintiff's counsel to respond to the early demand, and it also will help the insurance company later if there is a bad faith claim because you prove that you were diligent. And offer early mediation. The benefit of the early mediation is that the mediator should be able to obtain more information from plaintiff's counsel than plaintiff's counsel is willingly giving you during these very early phases. That also shows a good faith attempt to evaluate and settle the case. The next scenario is where there's a later policy limit demand and offer of judgment. This is not the rush scenario I just talked about. By now, significant discovery has been conducted. You've taken plaintiff's depositions, the party depositions are done, fact depositions have been taken, and expert depositions have been done. You've had a chance to evaluate liability, potential damages, you can give settlement ranges, you can give verdict ranges. And then you get the dreaded letter. Plaintiff's counsel has decided to write you a treatise telling you how bad your case is, that you will lose this case 100 out of 100 times that a jury hears it, that the damages are far in excess of the policy limits. In fact, the damages are in excess of what the plaintiff's counsel ever imagined the damages were until the day he penned the letter that he wrote to you. You will find out that your client is completely at fault for this situation that his client is in, and his client has no fault whatsoever. You send that to the insured and the insurance company, and then you need to be prepared for allegations of fault to shift from a co-defendant to yourself. You'll communicate with the co-defendant's counsel and plaintiff's counsel. Now, again, you're going to need to obtain as much information as you possibly can. The reason you need to buddy up with co-defendant's counsel is because you need to see if the same game is going on with them. You certainly don't want to be the last one holding the bag and then the offer of judgment is made to your client. You want to see if they're going to be around for the end of the game. You're going to be asked to revisit your evaluation and likelihood of success and the allegation of fault and range of damages. This will all come through coverage counsel because now what's going on behind the scenes, you obviously have nothing to do with the coverage analysis or any advice to the insurance company. But what's going on behind the scenes is coverage counsel is forced to evaluate the global settlement of the case, not just your piece of the case, but the global settlement. And they are going to be assigning their own percentages of fault and chances of success on the coverage analysis. Consider another mediation. I've done this, And the purpose of it is to continue to focus on the defense of the underlying case. By now, the horses are out of the barn, and the only thing the plaintiff wants to talk about is bad faith, because that opens it up to extra contractual damages and punitive damages. So their entire focus is on how the settlement process was a mistake on behalf of the defendants. You need to get the mediator to focus people on the underlying case. The next thing you need to do, be prepared to keep the trial judge focused on the case. The recent one I had, the judge was more interested in the bad faith aspect of the case than what I considered the low merits of the underlying case. In fact, another mediation was held. Coverage counsel needed to be there. My client's personal counsel needed to be there. And then everything from that, and we did try the case through the pretrial, focused on the bad faith claims. Resolution. Well, the further negotiations fail. So now we're not going to have a settlement. The policy limit demand is no longer on the table. Instead, what happens is plaintiff's counsel will make an offer to the insured for judgment in excess of the policy limits in consideration for not executing a judgment against them personally. And now your client has a lot of pressure. I mentioned earlier, you hope that they have personal counsel, because if they have personal counsel, you can concentrate on the trial and in getting a defense verdict. You do not need to also be thinking about, do I need to tell my client, the insured, you might want to roll over? If that doesn't work, there's a trial. There's an increased likelihood the plaintiff will settle with the co-defendant, especially if the co-defendant lacks insurance or ability to pay the entire judgment, because then when the big verdict comes in, your defendant is going to be responsible for all of that, and this assumes the case actually gets tried. Be prepared for plaintiff's experts to reevaluate the fault among the defendants, and I realize there's a lot of discovery issues involved there, and you can move in limine for this or that, but be prepared for it, because there's going to be a different story told when they're going after one party. Be prepared to present your own expert testimony against the co-defendant, even if the plaintiff presented testimony. Sometimes, if you see this coming in the middle of the case, you're able to actually get your own expert against the co-defendant. I realize there's a lot of disadvantages to that. And finally, there's increased focuses on the damages to decrease the likelihood of an adverse verdict. There's many cases where you go for broke and you're not going to talk about damages. Now it's factored in that you have two jobs. You hope you get a defense verdict, but if you don't, it better be below the policy limits. Thank you.